I never imagined that asking for permission to paint my front door a deep navy blue would spiral into a full-blown legal battle with the president of our homeowners association. Yet, that's exactly what unfolded the moment I collided with Karen Wilkins, the self-appointed enforcer of neighborhood perfection and easily the most intimidating person in Oakwood Estates. Everything began last spring when I decided my house could use a small exterior refresh. Before I even opened a can of paint, I did my due diligence like any careful homeowner would. I reviewed the HOA rulebook thoroughly. The written guideline stated that front doors were allowed to be painted in tasteful, muted colors that complemented the rest of the home. There was no list of approved shades, no bans, and no specific colors mentioned anywhere. Confident I was following the rules, I selected a timeless navy blue that matched my shutters exactly and submitted my request form, complete with paint swatches attached. 3 days later, an email landed in my inbox from Karen, its subject line written entirely in capital letters. Violation notice, unauthorized color selection. In the message, she claimed my chosen blue was far too bold and clashed with the visual harmony of the neighborhood. She instructed me to choose a color from a pre-approved list instead, which turned out to be nothing but dull variations of beige and pale gray. When I politely responded that these specific restrictions were not mentioned anywhere in the official HOA documents, her reply was curt and dismissive. The board has discretionary authority on aesthetic matters. Your request is denied. I've never been the type to quietly accept unreasonable power trips, so I formally requested an HOA hearing. That's when the situation took an odd turn. The hearing was delayed twice, each time for vague and questionable reasons. When it finally took place, Karen unveiled what she claimed was an amended bylaw showing that bright colors had been prohibited for the past 5 years. Almost immediately, I noticed something wasn't right. The font changed halfway through the document, and the page detailing the color restrictions looked noticeably newer than the rest of the yellowed pages. Despite my objections, the board, which seemed overly eager to agree with Karen, officially denied my request. Afterward, I decided to dig deeper. I reached out to the previous HOA president, who had retired to Florida 2 years earlier. When I mentioned the supposed color restriction amendment passed during his time in office, he sounded genuinely baffled. "We never approved anything like that," he told me. "In fact, we intentionally avoided color restrictions because the board couldn't agree on which colors should be allowed." Armed with that confirmation, I went to the county records office, where all legitimate HOA documents are required to be filed. Just as I suspected, Karen's amendment was nowhere to be found. What did exist was the original covenant, which contained only the vague language about tasteful and complementary colors. When I brought this inconsistency to 2 other board members, they shifted uncomfortably, but insisted Karen must be right. "She's very organized with paperwork," one of them said nervously. "She probably just hasn't filed the newest amendments yet." Unsatisfied, I sent a formal letter to the entire board asking for clarification regarding the conflicting documents. 3 days later, arrived home to find a certified letter waiting for me. It was from the HOA, signed by Karen herself. Inside was a list of alleged violations on my property and a $900 fine. The accusations included improper trash bin placement, unauthorized garden border stones, and excessive holiday decorations in April, despite the fact that I had no decorations up at all. It was obvious retaliation, but I refused to be bullied. I took photographs proving none of the violations existed and requested yet another hearing. Instead of responding normally, Karen escalated the situation by filing for an injunction against me. She claimed I was harassing the board and interfering with HOA operations. Even more shocking, she attached affidavits, supposedly signed by my next-door neighbors, stating that I had behaved aggressively and violated HOA rules. I immediately knew something was wrong. My neighbors, the Johnsons, were in the middle of a 3-week European cruise at the time those affidavits were allegedly signed. There was no possible way they could have signed them. When I called to confirm, they were furious that their names had been used without permission. That was the final straw. I contacted an attorney who specializes in HOA disputes and showed her everything. As she reviewed the documents, her expression grew serious. This goes far beyond an HOA dispute, she said. Forging signatures and falsifying legal documents are criminal acts. We need to take this straight to the court. We moved forward by filing a countersuit against the HOA and Karen personally, attaching every piece of evidence I had gathered showing clear document manipulation. The case was assigned to the Honorable Judge Marcus Rivera, a jurist well known for having zero tolerance for frivolous claims or courtroom theatrics. Given the seriousness of the forgery accusations, he scheduled an emergency hearing to address those issues before even considering Karen's request for an injunction. When the day arrived, my nerves were on edge as I stepped into the courtroom. Across the aisle sat Karen, impeccably dressed in a sharply tailored suit, her posture stiff and confident. She didn't bother looking at me, instead focusing on neatly arranging stacks of paperwork beside her attorney, a smooth-looking man whose expensive suit matched his polished demeanor. Once Judge Rivera entered, the proceedings began immediately. Karen's attorney opened by arguing for the injunction, portraying me as a defiant homeowner unwilling to follow established rules. He dramatically waved the questionable amended bylaws in the air, presenting them as undeniable proof. When it was our turn, my attorney remained calm and methodical. She submitted certified copies of the official county records, written statements from the former HOA president, and, most damaging of all, sworn affidavits from the Johnsons confirming they had never signed the documents Karen provided. The Johnsons also submitted evidence proving they were out of the country during the alleged signing dates. Judge Rivera's expression hardened as he compared the documents side by side. These signatures don't appear to match the Johnsons' verified signatures on file, he observed, peering over his glasses directly at Karen, who had begun shifting uneasily in her chair. Miss Wilkins, did you personally witness these signatures being signed? Karen cleared her throat, her confident FAD starting to crack. I received them via email, Your Honor. I printed them for submission. The judge requested to see the emails. Karen's attorney leaned over and whispered urgently, and she fumbled with her phone before stating she couldn't locate them at that moment. Judge Rivera was visibly unimpressed. He then lifted the suspicious bylaw pages. And these HOA amendments? The county has no record of them, yet you're enforcing them as legally binding. Karen launched into a rambling explanation about administrative delays and filing backlogs, but the judge cut her off mid-sentence. This court takes allegations of document falsification very seriously, Miss Wilkins. I am ordering a full forensic examination of every document submitted. The color drained from Karen's face. Her attorney requested a brief recess, which the judge allowed. When we reconvened 30 minutes later, Karen looked nothing like the confident HOA president from earlier. Her hands trembled as she whispered repeatedly to her attorney. The forensic examiner needed little time to conclude. The amended bylaw pages had been printed recently, not 5 years earlier as claimed. The paper stock didn't match the rest of the document. Most damning of all, digital analysis revealed the Johnsons' signatures had been electronically copied from HOA membership forms and pasted onto the affidavits. Judge Rivera's patience was gone. Miss Wilkins, stand up, he ordered, his voice echoing through the silent courtroom. Karen rose unsteadily, her eyes darting as if searching for an escape. Based on the evidence presented, I am dismissing the injunction against the defendant. Furthermore, I am referring this matter to the district attorney for investigation into document fraud, forgery, and perjury. Bailiff, take Miss Wilkins into custody. A collective gasp swept through the room as the bailiff approached Karen, who stood frozen in disbelief. This is absurd, she shrieked, her voice rising to the sharp pitch I recognized from countless HOA meetings. I am the president of Oakwood Estates. HOA, you can't treat me like a criminal. Judge Rivera didn't flinch. The law applies equally to everyone, Miss Wilkins, regardless of their position in a homeowners association. The bailiff placed her in handcuffs as she began to sob. Turning to me, the judge spoke plainly. Sir, you are free to paint your door any color permitted under your actual HOA covenants. I also recommend that the remaining board members hold an emergency election to replace their leadership. As Karen was escorted out, she glanced back over her shoulder, mascara streaking down her cheeks, her face twisted with rage and shock as her perceived authority collapsed under real justice. The last words I heard before the courtroom doors closed were, "This isn't over. I've given everything to this neighborhood." Judge Rivera set her bail at $25,000 and ordered her to surrender her passport while awaiting trial on multiple felony charges. When the gavel finally struck, ending the hearing, I felt an enormous weight lift from my chest, one I hadn't even realized I'd been carrying all along.